Question 851. Listing agreements can be recorded with a title company if A. Both parties agree. B. The broker has a signed agreement with the title company. C. The owner fails to file a written objection within 30 days of signing the listing agreement. D. Listing agreements are not recorded. Correct answer is D. Listing agreements are not recorded. The primary purpose of recording documents with the county recorder's office is to provide constructive notice to the public of interests in real property. This includes deeds, transfers of ownership, mortgages, deeds of trust, liens, easements, and other encumbrances that directly affect the title or possession of the property. Recording protects innocent third parties by making these interests public. A listing agreement is a contract for services between a property owner and a real estate broker. It grants the broker the authority to market and sell the property and establishes their right to a commission. It does not directly transfer ownership, create a lien, or establish an interest in the property's title that requires public notice in the same way deed or mortgage does. In California, recent legislation, Assembly Bill 1345, effective January 1, 2024, specifically prohibits the recording of exclusive listing agreements for residential real estate. This prohibition was enacted to curb predatory practices where certain companies would record long-term listing agreements, essentially placing a lien on a homeowner's title. Such actions trapped owners, making it difficult to sell or refinance their property without paying excessive fees. Such actions trapped owners, making it difficult to sell or refinance their property without paying excessive fees. The new rule ensures these agreements can't be used to encumber a home's title. This legislation further solidifies the principle that listing agreements are not instruments that should be recorded. Therefore, listing agreements are generally not recordable instruments because they do not convey or encumber title to real property in the way that other recorded documents do. Question 852. A listing broker asks another broker to assist him in procuring a buyer for the listed property, and they make an oral agreement to work together. This other broker, called the cooperating broker, succeeds in finding a ready, willing and able buyer to make the purchase. However, the listing broker refuses to share his commission payment with the cooperating broker. The cooperating broker A may not recover his commission split because the agreement with the listing broker was not in writing. B may recover his commission split by pursuing the matter in a legal proceeding. C should ask the owner to pay him his share of the commission. D may not recover his commission split because only one broker can be paid per property transaction. Correct answer is B may recover his commission split by pursuing the matter in a legal proceeding. While a written agreement is ideal, it's not always required. In many cases, oral agreements between brokers to cooperate on a real estate transaction are enforceable. If a cooperating broker can prove an oral agreement and that they produced a ready, willing, and able buyer, they can likely recover their commission share. They may pursue legal action to enforce this valid claim against the listing broker. The key factor is whether there was a clear understanding between the two brokers about the commission split. If the cooperating broker can provide evidence of this agreement, they may have a strong case for recovering their commission. The cooperating broker cannot directly ask the buyer to pay their share of the commission. The commission is typically paid by the listing broker. It's common for multiple brokers to be involved in a real estate transaction, and they can all be entitled to a share of the commission, as long as there is a clear agreement in place. Question 853. A real estate agent tries to persuade a group of people in a neighborhood to list their property for sale with the agent because members of a minority ethnic group are planning to move in, which the agent warns will lower overall property prices in the community. The agent's conduct can be termed all of the following, except A. Blockbusting. B. Panic selling. C. Against the regulations of the real estate commissioner. D. Illegal, but not against the regulations of the real estate commissioner. Correct answer is D. Illegal, but not against the regulations of the Real Estate Commissioner. Blockbusting is a discriminatory and illegal practice in real estate. Agents induce homeowners to sell their properties by creating fear that the entry of a particular racial or ethnic group into the neighborhood will cause property values to decline. This exactly matches the agent's actions described. Panic selling is the direct result that blockbusting aims to achieve. The agent is trying to create panic among the homeowners to make them sell their properties quickly and often at a lower price. Blockbusting is explicitly prohibited by federal fair housing laws, like the Fair Housing Act of 1968, and by state real estate licensing laws and regulations, including those enforced by the Real Estate Commissioner in California, DRE. Engaging in such behavior would lead to severe disciplinary action, including license suspension or revocation. Therefore, blockbusting is illegal under federal and state law, and state real estate commissions are responsible for enforcing those laws among their licensees. It is absolutely against the regulations of the Real Estate Commissioner. Their regulations specifically prohibit discriminatory practices like blockbusting. Question 854. Someone who is designated to carry out a specific transaction is called A. Secret agent, B. General agent, C. Special agent, D. Transactional agent. Correct answer is C. Special agent. Secret agent usually refers to a spy or an undercover operative, not a legal agency relationship. A general agent is authorized to conduct a series of transactions or a wide range of business activities on behalf of the principal. Their authority is continuous and extends to all matters connected with a particular trade or business. A property manager, for example, might be a general agent for an owner. While some states recognize transactional brokers, or transaction brokers, this is a specific role in real estate, where the broker facilitates a transaction without representing either party as a fiduciary. It describes a type of agency relationship, or lack thereof, not the general legal term for someone designated for a specific transaction. The broader legal term for someone designated for a specific transaction is a special agent. A special agent, or specific agent, is authorized by a principal to perform a particular act or transaction. Their authority is limited to that specific task, and they do not have ongoing authority to bind the principal in other matters. In real estate, a real estate broker acting under a listing agreement to sell a specific property is typically a special agent. Question 855. The concept of present worth of future benefits relates to A. Market value, B. Income, C. Rental properties only, D. Commercial property only. Correct answer is B. Income. The concept of present worth of future benefits is most directly and explicitly applied in real estate appraisal when determining the value of income-generating properties. Income approach to appraisal approach directly estimates the value of an income-producing property by converting its anticipated future income streams into a single present value. This process is called capitalization. For properties like apartments, office buildings, or retail spaces, the future benefits that a buyer anticipates are primarily the net income those properties will generate over time. The capitalization process takes that expected future income and discounts it to its current equivalent value, which is the present worth. The concept of present worth of future benefits broadly applies to all properties, as even a home offers the future benefit of shelter. However, its most direct and mathematically explicit application in real estate appraisal involves the capitalization of income. This technique converts anticipated future income streams into a single present value, primarily for income-generating properties. Therefore, income is the most accurate and specific answer as it directly ties to the primary method where future benefits, in the form of income, are converted to a present value. Question 856. sale or rental transactions of properties built before require a lead-based paint disclosure. A. 1998, B. 1988, C. 1978, D. 1968. Correct answer is C. 1978. Lead-based paint was commonly used in homes built before 1978. To protect public health, especially children, federal law requires sellers and landlords of pre-1978 housing to disclose known lead-based paint hazards. This disclosure helps buyers and renters make informed decisions and take necessary precautions to mitigate lead exposure risks. Buyers of these houses must be allotted a 10-day period to conduct a paint inspection or risk assessment for lead-based paint or lead-based paint hazards. The Consumer Product Safety Commission banned the use of lead-based paint in residential properties in 1978, making that the cutoff year for the disclosure requirement. Question 857. Broker Charles took a listing to sell a home. The owner told Charles over the phone that the property was in good shape, and Charles never inspected it. The owner showed a buyer the property, and the buyer decided to open escrow with the owner, which then closed a few months later. Which of these facts are true? A. Charles has violated the law. B. Charles has not violated any law because the property has no material defects. C. Charles has not violated any law because the buyer did not ask him any questions about material defects in the property. D. The owner has violated the law. Correct answer is A. Charles has violated the law. Real estate agents have a duty to inspect properties listed for sale and disclose any known material defects to potential buyers. Even if the seller claims the property is in good condition, the agent should conduct a reasonable inspection or verify the information provided by the seller. In this case, Charles failed to fulfill his duty of care by not inspecting the property. If the property had undisclosed defects that were discovered after the sale, Charles could be held liable for damages. It's important for real estate agents to prioritize transparency and honesty in their dealings with clients to avoid legal and ethical issues. Question 858. Jason conveys an apartment he owns to Richard for 1 month. The property interest held by Richard can be called A. Non-freehold estate, B. Term for years, C. Either A or B. D. What Richard has cannot correctly be called a property interest, the rental period is too short. Correct answer is C. Either A or B. When Jason conveys an apartment to Richard for a fixed period of 1 month, Richard holds a leasehold estate. Leasehold estates are distinct from freehold estates, which involve ownership. Non-freehold estate term encompasses any property interest that is less than a freehold estate. Leasehold estates fall under this category. Richard's interest for 1 month is certainly a non-freehold estate. Term for years, or estate for years, is a specific type of leasehold, non-freehold, estate for a definite, fixed period of time. The duration can be anything from a few days to many years, as long as it has a specific beginning and end date. Richard's interest for exactly 1 month fits this definition perfectly. Any legal right to possess or use property, even for a short time, constitutes a property interest. Since a term for years is a specific type of non-freehold estate, both terms correctly describe Richard's property interest. Question 859. An agent owes a duty of honesty to A. Third parties, B. Real estate commissioner, C. Title company, D. None of the above. Correct answer is A. Third parties. An agent owes a fiduciary duty, which includes honesty, loyalty, confidentiality, etc., to their principal. They also owe a fundamental duty of honesty, fairness, and disclosure of material facts to all other parties involved in a transaction, third parties. This means an agent cannot intentionally misrepresent facts or engage in fraud, even with someone who is not their client. Question 860. An estate of indefinite duration is called an A. Lifetime estate, B. Estate of inheritance. C. Freehold estate. D, B and C. Correct answer is D, B and C. In real estate, estates are generally categorized based on their duration. Non-freehold estates, or leasehold estates, are for a definite and limited duration, e.g., a lease for 1 year, a month-to-month tenancy. Freehold estates are estates of indefinite duration and involve ownership interests in real property. They can potentially last forever or for the lifetime of a person. An estate that descends to an heir and thus endures throughout 2 or more lives, hence the indefinite years aspect. Note, though, that not all freehold estates are estates of indefinite duration or estates of inheritance. Other freehold estates are referred to as estates not of inheritance, or life estates, which exist only for the term of a person's life. The ordinary conventional life estate with remainder or reversion, for example, does not continue for an indefinite period, but terminates when the person on whose life the estate is based, or the life tenant, becomes deceased.